As mentioned, I'm going to start us off by talking about COVID-related leaves under the Families First Coronavirus Response Act. I'm going to give you a general overview and then go into detail into some of these provisions. So to begin with, both of the emergency paid sick leave and the expanded FMLA began April 1st. Neither is retroactive and they're set to expire on December 31st of this year. For the emergency paid sick leave, there's 6 qualifying reasons that we'll go into a little bit down the road. An employee can take up to 80 hours of emergency paid sick leave, and they are entitled to full pay or 2/3 pay, depending on the reason why they take this leave. Now, as for the expanded FMLA, there's only 1 qualifying reason. Now, the employee must be unable to work or telework to care for a minor child due to the child's school being closed or the place of care not being available. And for this leave, the employee can take up to 12 weeks. The first and second week are unpaid, and weeks 3 to 12, the employee can receive 2/3 pay. I do want to point out that for the emergency paid sick leave, this is an additional leave that's in addition to any other leave that the employee might already have, like vacation time, etc. The employer can't force the employee to first exhaust that before they can go on this emergency paid sick leave. As for the expanded FMLA, the employee has 12 weeks of FMLA or expanded FMLA during a 12-month period, meaning that if they have already used some of their FMLA time prior, they may be limited on the amount of time that they can take for the expanded FMLA. However, let's say that they've exhausted their FMLA, they are still able to take the emergency paid sick leave if they qualify under the provisions. Now I want to go more into detail about the 6 different reasons that an employee can take the emergency paid sick leave. The first being if he or she is subject to a federal, state, or local quarantine or isolation order related to COVID-19. Now, for this reason, there has to be an order and the employee must have work for you to do. So if the employer does not have any work, then you can't qualify for this reason. So an example of this is, let's say you go on a cruise ship and after the government says that, there was someone infected, so you have to self-quarantine for 14 days, then and your employer is open, of course, then you'd be able to take this leave, but just make sure that you also cannot telework. And for the second reason, if an employee has been advised by a healthcare provider to self-quarantine related to COVID-19. Now, for this reason, we had a client who actually was advised because of his underlying medical conditions, making him more vulnerable to the virus. And his healthcare provider advised him to do so, so that would be a qualifying reason. And for number 3, if the employee is experiencing COVID-19 related symptoms and is seeking a medical diagnosis. Now for this one, the key word here is and. The employee can't merely take this leave if they're not feeling well, feel like they have symptoms. They have to be, seeking a medical diagnosis, see if they have it, or, they have been advised by their healthcare provider to self-quarantine. Moving on to number 4, an employee can take this leave if he or she is caring for an individual subject to an order as described in 1, or they have to self-quarantine because they've been advised to do so by their doctor. For this one, an individual does not have to be an immediate family member. It can range, or someone even related to the employee. But it does have to be someone who regularly, who possibly resides in your home, or someone that because of your relationship with them, there's an expectation that you would care for the person in a quarantine or self-quarantine situation. So it can't be a stranger that you met pre-quarantine at a bar, for example. It has to be some relationship. And for number 5, an employee can take this leave if their minor child's school or place of care is closed for COVID-related reasons. For this one, it's important to note that only one caretaker can take leave for this reason, so not both parents can take the leave. In addition, a minor, if the child is over 14, the employee must provide a statement of special circumstances why they're seeking this leave for the child. If the child is over 18 and disabled, they might still qualify for this leave if, you know, the disabled child is unable to take care of him or herself due to their place of care being closed. And for number 6, the last one, if the employee is experiencing any other substantially similar conditions specified by the Secretary of Health and Human Services in consultation with the Secretaries of Labor and Treasury. What does that mean? So there hasn't been any clarification. The U.S. Department of Health and Human Services has not identified any substantial or similar condition that would allow an employee to take this paid sick leave. But when this condition is identified, we'll receive some guidance from the DOL. And just to note, for all of these reasons, it's important that the employee cannot telework as well. As far as calculating how much pay, I think we kind of went into that in the first slide. You know, for reasons 1, 2, and 3, the employee can receive full pay, but there is a cap of $511 a day and $5,110 in the aggregate over 10 weeks, or over 2 weeks, I apologize. And for 4, 5, and 6, it's 2/3 pay. For number 5, it's for up to 12 weeks, you know, with the expanded FMLA. And for 4 and 6, it's for 2 weeks. And as we mentioned previously, the duration of the leave, most of these except the child care being closed is for 2 weeks, and the other one is 12 weeks. So who qualifies for these leaves? An employee, for the emergency paid sick leave, the employee is eligible on their first day of employment. And it both include full-time and part-time employees. And a part-time employee is defined as someone who works less than 40 hours. For the expanded FMLA, an employee is eligible after working there for 30 days. For the employees that are not included for these leaves are healthcare providers, emergency responders, and employees who work for companies with 500 or more employees. For the employers covered, it's private employers with less than 500 employees. And generally for this number, all employees are counted except independent contractors. So that includes temps who are working through temp agencies and employees who are on leave, but it does only include those working within the US. And to determine if 2 or more entities are combined or separate for purposes of this number, the DOL has adopted the integrated employer test under the FMLA to make that determination. As you may know, small businesses with less than 50 employees may be exempt from providing leave to their employees due to school closings or childcare being unavailable. However, this exemption can only be used for that reason. Due to the closings or childcare unavailable, the other 5 reasons are not exempt. So the small employer would still need to provide the leave. As part of the employee protections, there is an anti-retaliation provision for employees who take the extended leave or the emergency paid sick leave. And also, of course, if they seek any type of complaint regarding this. Now, under these leaves, they will be restored to their same or equivalent position. However, this does not apply to key employees or to employees that work at businesses with 25 or less employees. And we'll go into that in the next slide. Enforcement began on the 17th of April, and investigations on these types of complaints are being done by the U.S. Department of Labor, their Wage and Hour Division. So as I mentioned, if the employer has less than 25 employees, they don't have to return the employee back to their position if any of the following qualify, and I'm not going to read them word for word. However, the employer does have to make reasonable efforts to contact the employee and try to put them in an equivalent position if one becomes available, and they have to do this for a year. As far as the information required when requesting this leave, it just varies depending on the type of leave that the employee is seeking, or the qualifying reason. Most of this information can be found on the DOL's website. The request can be verbal or it can be written. As far as timing goes, I know that's a big question right now. So for school closures, the notice must be provided as soon as practicable. And for all other reasons, employers can only require the employee to provide notice after the first workday that an employee takes emergency paid sick leave. While there are certain pieces of information that need to be provided, the employer is allowed to ask for additional documentation.
Our next speaker is Kim Hilton. As Quentin introduced her, Kim handles most of our firm's employment contracts, severance negotiations. She probably negotiates more severance agreements than any other lawyer in the state of Illinois. She probably does, anywhere from 100 to 200 a year, and knows this stuff really well. And she deals with unemployment issues all the time. So she's going to tell you all about unemployment and what's going on at IDES. Don't forget to unmute yourself.
I gotcha. I will tell you about IDES to the extent that I know. And to be perfectly honest at this point, the unemployment rules were changed in response to the COVID pandemic, and they're a little, we'll call them fluid at this time. Things are changing all the time. A lot of sort of declarations were made from the governor and others, and the agency didn't have the infrastructure or the rules in place to implement some of those changes. So we're just sort of on some level flying by the seat of our pants until we can figure out what we're supposed to be doing. Is that you no longer need to wait a week for your benefits. You no longer need to necessarily apply for other jobs, although you still do need to certify. And you need to say that you are available to go back to the job that you had. You're not necessarily required to go out and seek jobs somewhere else, but you still need to be willing to go back. And one of the questions that we received before the presentation today was, can an employee refuse to go back to work if the work is being offered to them? And I think the short answer to that is no. If you're certifying that you're able and willing to go back to work when your place of employment opens back up and you're being offered to go back, I don't think you can refuse and still qualify for benefits. One of the reasons that the questioner asked about that is because at this point, a lot of people are actually making more money on unemployment than they did while they were working. And the reason for that is because in addition to the weekly benefit amount that they get under the state unemployment, the federal government under this PUC Act has kicked in an extra $600 per week for each person. And I'll go through a little bit later about how the benefits break down. But for low wage earners, they're not making a lot in state unemployment per week. That $600 is a lot of money, and in a lot of situations will kick them over actually what they were earning before. In Illinois, the $600 a week PUC benefit didn't start until April 6th, even though it was announced well before that. It just took Illinois a while to get that to kick in. Under the state benefits, any employee is entitled to 26 weeks of benefits. Under the federal laws at this point, there's an additional 13 weeks for a total benefit of 39 weeks. And that includes any benefits that you were receiving prior to the shelter-in-place orders or anything like that. The changes to the unemployment now rules now make independent contractors, self-employed individuals, and gig workers eligible for unemployment. However, this is another one of those things. It was announced a long time ago that these folks would be getting benefits. They still don't have them. The governor said as late as last Friday that folks should be applying for unemployment as independent contractors, and they're probably going to get denied, but they're supposed to get put in some pile somewhere to be reevaluated, and that they're hoping that the benefits start in mid-May, but there's no real answer on any of that yet. It's another one of those sort of changing areas where we just don't know. As an independent contractor, though, you are not getting the same benefits as a regular W-2 employee. You're only getting half of the state unemployment, but you do get the $600 federal benefit. So it's, you know, certainly a lot better than nothing. That leads us sort of into who is eligible for unemployment now. A really good reason for that. So generally, you're eligible for unemployment benefits if you lost your job because of COVID, but you are not eligible if you did not fully lose your job, if there's only been a reduction in work hours, or if you are receiving any sort of paid leave. So if you're getting the childcare leave that Thalia talked about, you're not going to be able to double dip and collect unemployment benefits as well. However, if you have been laid off due to COVID and you received a severance package, those severance benefits do not make you ineligible for unemployment. So you can, in that way, double dip. But in just about any other way, you're not going to be able to get payment from your employer and also get unemployment from the state. How much you going to get? Employment getting 47% of your weekly earnings. There's a very complicated formula that the IDES uses to calculate what your average weekly earnings are. Basically, they're looking at your highest 2 earning quarters of the last year-ish, and you get 47% of that for a maximum benefit of $484. Now, that's the state benefit. So on top of that, you're getting the $600 per week from the feds. So at some point, right, if you are anywhere under the maximum benefit, you're earning less than $600 a week on state unemployment. And then when you add the federal benefit in, you are getting a whole lot more. You can get more than 47% if you have dependent spouses or children. And so that is how people can try to get closer to half of their earnings in normal circumstances, and then the extra 600 right now. You can work and earn up to half your weekly benefits and still get receive some benefits, but they will start deducting, and at some point you're going to get 0. This chart, I've added the link for this chart, and it has, for me, been a real lifesaver when people call in and just want to know sort of what they can expect. It's a great way to kind of eyeball where your client would end up if they were collecting unemployment. Just sort of, to me, I don't mess with that first column. From the second column, just kind of have them guesstimate what their average weekly take home or average weekly gross pay is. And that leads you right into the weekly benefit amount. And then you can tack on the additional percentages for dependent spouses and children. It's a very handy little tool, and I've found it to be really, really, really helpful in counseling people about what they can get in unemployment. Major challenges in filing for unemployment. In that first week that they sort of opened the floodgates, there was 178,000 Illinois residents who applied for benefits. And David, the answer is you really can't call the IDES anytime you want because they've been so overwhelmed. They're asking people not only to only apply certain days of the week because they can't handle it. They're asking people only to call certain days of the week because they can't handle it. The catch-all day for calls being Friday. My sisters have applied for unemployment and have been sharing with me their trials and tribulations as they work through the system that was never designed to handle this kind of volume. And I've been told, sorry, by both of my sisters that if you have to call, just good luck, because you will, if you do get through, you're on hold for 2 to 3 hours. Every time you call, you have to go through the automated system, put in all of your information. And it's only then after you've done all that, that you're told all circuits are busy, call back later. Or maybe you get put in a call queue and maybe 2 to 3 hours later, if your phone battery lasts that long, you might be able to get to talk to somebody. The IDES and trying to limit who calls when and who applies when is obviously their way to mitigate some of those issues, but it's not 100%. It's not really working. They just don't have the infrastructure to handle the influx of people applying that they did. So hopefully, they'll get through it soon, and that flood of people that were applying will subside as people are already out of work, or as businesses start to reopen in the not so very distant future. That's really the hope here. So that was all I had.
All right. So last but certainly not least, we have Seth Matus. Seth has been a lawyer for over 20 years, and he handles a lot. He's of counsel to our firm and handles a lot of business litigation, representing employers, and all sorts of different crazy litigation matters. So Seth is going to kind of give this from the employer's perspective and things that employers should look out for.
All right, everyone. Thank you very much. Thanks, David. I do want to change perspective and talk very briefly about some of the issues facing employers, which I think are really quite daunting. Let's just go quickly through this. So first of all, let's talk about one of the main issues that are facing companies that have their employees working remotely. One of the issues which I've already seen, and I think could actually be a big issue, is how do employers handle confidential and personal information when employees are working from home? I think that you've already seen that it's much more difficult for employees to sort of understand what's happening with technology. When you are at an office, a lot of times you might have an IT staff who can really sort of explain some of these issues. But for instance, most home systems Wi-Fi's are really terrible. They're very easy to hack into. Likewise, anything, say like with an email, if you send confidential information via email, that's something which a hacker can very easily access. So really what employers need to start thinking about is how are they going to do this? There needs to be standards that are told to the employees, and also employees need to be educated. And there's a real legal reason why this needs to happen. And that's, of course, having to do if an employer is ever going to try in the future to bring a case based upon the Trade Secret Act, non-compete agreement. All of those cases are premised upon an employer making sure, taking reasonable steps to protect his confidential information. So it's not going to really go anywhere in any of those kind of cases. So again, this is a developing area of law, but I really do recommend that we counsel all of our clients that they start thinking about this. Here's another area. What happens when information is being stored in someone's home computer? Is an employee's computer actually going to be encrypted? All of these things are the types of matters that employers really do need to be aware of and thinking about what they're going to be doing and acting proactively. Here's another issue. What about the FLSA? Especially when we're talking about non-exempt employees, it's incumbent upon employers to be tracking time. Employees working remotely, it creates a real hassle for employers. And any employer needs to figure out what kind of system it's going to be using to have employees record their time. There's another part which comes with remote working. I have this issue of myself, I'm sure everybody else has, but when you're working remotely, your day is constantly jumbled. Whether you're just constantly working or whether you get interrupted by your spouse or a child or a dog, it is much more choppy than it is in an office. And so all of those types of issues need to be discussed with employees, and an employer needs to set standards for what is going, how they need to track time and what's going to be acceptable. Now, third, I've had a number of questions from clients, from employers. What happens when you have an employee who just doesn't seem to be doing a lot of work while working remotely? And so for here, I guess that, certainly in this situation, we need to be, employers need to be somewhat compassionate. But at the end of the day, I mean, if an employee is working remotely, and if there's not an issue like with technology or someone being sick, whether COVID or not, you can certainly treat that kind of employee like you would a non-productive employee who happens to be working out of an office. Changing gears, let's now talk about essential businesses, the companies that are actually staying open right now and having their employees coming into the office or store every day. So what are some of their issues? Well, most basically, how do you protect your workers from COVID-19? There's an initial question. Well, do you have a legal obligation to do so? And the answer to that is evolving, but increasingly people are agreeing that OSHA, the Occupational Health and Safety Act, is requiring employers to take basic steps to prevent employees from developing COVID-19. If it's a open and obvious hazard, that's a standard under OSHA, and they're beginning to agree that that is the type of situation. So how does an essential business go about doing that? Jump the gun here a second. But basically, I think that for most employers, in terms of protecting their employees from COVID-19, you need to be following CDC guidelines. You need to be taking those types of measures. And that's one way in which you can, prevent any OSHA violations. There is another part of that too, and that has to do with giving any kind of defense if there's ever a claim in the future for negligence, for wrongful death. Certainly if an employer has been proactive, has been following CDC guidelines or OSHA guidelines, that's the type of thing that would begin to create a defense for an employer. Now, I had jumped the gun. Let's talk really briefly about testing. And certainly that's one thing a lot of employers are beginning to adopt. I mentioned problem. The problem arises out of the Americans with Disabilities Act. And the ADA mandates that any kind of testing be performed, it needs to be kept confidential, and it can only take place in certain situations, when we're talking about employees. Now, the EEOC has recently issued some guidance, and it does indicate that the COVID emergency is the type of situation in which it is permissible to test employees. And so it is entirely fine if an employer wants to take the temperatures of employees as they're coming in. It's entirely fine if an employer wants to ask its employees whether they have any symptoms of COVID-19. But of course, keep in mind that what is the case here is that all of that needs to be kept confidential. Now, additionally, the other thing is that the EEOC has indicated that it is also fine to take other tests so long as they're accurate. And the issue, of course, that we have is that, the testing, the different tests that have been developed, they're not quite so sure how accurate they are. So that's an issue which also might be arising further as this crisis continues. Here's another issue. So, as I mentioned, OSHA basically does mandate that employees protect their workers. And, again, to present any kind of defense, they knew employers need to go forward and to take basic steps to, ensure workplace safety. Again, that goes back to OSHA, goes back to CDC guidelines. Those would be the types of things I recommend any of my clients to adopt. But more holistically, I think that what employers really need to do is to really examine every aspect of their operation. And by that, most of the focus has been on employees. But there's other areas, other possible risk vectors that I think employers need to consider. For instance, what about vendors? What about any type of business travel? Employees can really begin to get exposed in a lot of different ways. What I recommend that employers do is they consult with any of their vendors, make sure their vendors are actually taking appropriate steps. Employers might also want to be talking about with their landlord, or if they have their own cleaning service, how often is the building being cleaned? And those types of things also are issues that potentially could help an employer establish that it is actually protecting its workers from COVID-19. Now, finally, I'm sorry, one more thing. Again, recalcitrant employees. What should be happening for employees who are just refusing to come into work? It really does depend. Now, certainly, as Kim mentioned, if an employee just has a generalized fear, they don't want to come into the office, they don't want to come into the store because of a fear of COVID-19, that in and of itself doesn't give that employee any kind of protection. And I think in that situation, an employer would be warranted and wouldn't really face much risk if it actually terminated the employee. But I want to be very cautious here. And that's because if any employee starts complaining, as we've already seen, say, with Amazon, as we've seen with, there were a number of hospitals in Chicago, when you actually have employees start to complain about their work conditions, anytime that they are doing that is a type of situation in which the employee might possibly have a claim under the National Labor Relations Act. It possibly might be under OSHA. The employee might be able to make a claim as a whistleblower. So that's a situation in which I would counsel an employer to be very cautious. All right. Now, finally, what about reopening employers? What should companies which are going to be, once this crisis ends, the stay-in-place order is lifted, what should they anticipate? Well, I think that really what needs to be focused on is that even though the situation is totally different, employers still need to consider the good old employment laws that have already been in place. And I've already alluded to a few. Let's talk about a few more. So how about when you are recalling people from layoffs, or if you have to continue to make additional layoffs? These are always very fraught situations. And I think that for any employer, they need to anticipate that this is the type of situation in which you would have an employee who could possibly make a discrimination claim, retaliation, any of those types of claims. So for those employers, if they have to go through those types of situations, it is critical that they have some sort of neutral process in determining who's going to be recalled, who's going to be laid off. How about the Americans with Disabilities Act? For a number of employers, if they happen to have employees who have some sort of compromised immune system, those employees might not be able to come back to work right away. They might need some sort of additional reasonable accommodation above and beyond the type of protection that the employer is already giving to normal employees. And so whether that is something where they allow the employee to stay at home or something else, employers should anticipate that issue. And likewise, if you have somebody who, say, is allergic to latex gloves, if the employer is mandating that the employees wear gloves, there needs to be some sort of workaround to, accommodate that employee. Here's another thing. I mean, it's sad to say there has been a number of incidents where Asian Americans have been harassed. They've been claimed to, be the cause of the pandemic. I think that here is going to be another area where a lot of employers might have problems. And I think it might be important for employers when they recall employees back to the office, back to the store, whatever it is, that they emphasize that any of this kind of harassment is not going to be tolerated. And again, just like they would with any other type of harassment claim, just be aware that they could be coming and take swift action. Finally, I think that employers, as I alluded to before, need to be very aware that, you know, there could be some really serious claims asserted, but either through a workers' comp claim or wrongful death, negligence, arising out of employees who claim that they catch coronavirus at work. And I think that, again, as I alluded to before with essential businesses, employers really need to be developing a plan now for all the steps they're going to be taking. As I said, it is a bow to stern type of examination of their work environment. And if they do that, if they start taking those steps now, I think they're going to be well situated for any possible claim in the future that might arise. So that's really all that I have for right now. I'm going to turn things back over to David.
I suppose we can take some questions. There's been some posted, and we've been trying to answer those as we've been going, but I'll read some of them. Kim, why don't you answer this one? Can an employee work a little bit, say 5 or 10 hours a week, for either its current employer or another one, and not jeopardize their unemployment eligibility for benefits?
Generally, yes. It's not really about how many hours you work. It's more about how much money you make. So that goes to you can earn up to half of your weekly benefit amount without losing your unemployment benefits, but they will jeopardize to the extent that you will have less benefits. It's going to happen. They're going to sort of deduct dollar for dollar until you are no longer eligible.
By the way, our winner was Rebecca Obarski, Councilwoman Rebecca Obarski. No surprise there that she won. She's really smart. So congratulations, Rebecca.
And hold on one second, David. Nancy, the answer to your question, yes, the state benefit.
So then several people have asked, can we get copies of the presentation materials? And yeah, we'll send out a link or something where you can download them, or we'll email them to you. We'll do that. Let's see. A couple more. Okay, maybe for Seth. What about notifying other employees of a positive case of an individual employee?
Well, to answer that, I think that is absolutely something that employers must do. They need to notify other employees that they've been exposed in order to minimize risks. But what I would recommend that they do is they not identify who it is who actually they're suspected of having coronavirus or COVID-19. That would begin to possibly infringe on the ADA. But certainly, by all means, they do need to know.
We had a call from somebody the other day who 20 people tested positive at his work site, and he was pissed because they suspected that somebody was sick, and they kept asking, and the employer kept reassuring everybody that everything was okay. And then, shortly thereafter, 20 people got infected, and they ended up shutting down the plant. And so, I don't know exactly what their claim's going to be, or if they'll have one, but they're really upset, understandably, that their employer lied to them and didn't tell them about it. So I think that transparency is important. Nancy Fallon asked, and this is probably for Seth also, can the infected employee choose to disclose who they are to their coworkers, the other employees?
Sure. In that situation, that would be fine because it's the employee who's choosing to do that. But I wouldn't recommend that an employer actually do that.
There's a question. Just to clarify, can an employer force an employee to work if they don't have childcare? Maybe Thalia?
Sorry, I had to unmute myself. So it really depends. I mean, it depends if the employer has more than 500 employees, and it also depends on that employee's position, if they're a first responder, healthcare worker.
Okay. There's one, if someone contracted COVID at work, how do they go about obtaining proof that it was contracted at the workplace? I think that's a real interesting issue. You know, there was the governor issued the executive order saying there's a presumption that if you're a kind of a frontline worker that and you contract it, you would be able to get workers' comp because it would be presumed that you got it in the workplace. But that was challenged by the Illinois Manufacturing Association and some others. And so that's no longer successfully challenged. And so that's no longer the case. I think if you're still if you're a nurse working in an ER treating COVID patients and you get tested, I think, you know, you have a pretty good case that you got it in the workplace and you should be able to get workers' comp. I think otherwise it would be hard to prove that. You know, I suppose you could try, but I think it would be hard. But I think especially with death cases where people are dying, maybe some, you know, people who are on ventilators for a long period of time, but certainly for death cases, I think we will see workers' comp cases being made, but they'll have to prove that they got it in the workplace. And obviously if the person's dead, you know, that's one strike against them proving it. You know, I suppose they could have their family like testify, you know, they didn't go anywhere else and nobody else in our family had it, or, you know, whatever. But I think that's going to be a tough thing to prove.
I'd like to just jump in, David. I'm aware already that there has been a wrongful death case that was filed over in the Cook County Circuit Court against Walmart, an employee who did pass away. So it's a wrongful death case. And the basic claim is that Walmart failed to take basic steps to avoid, you know, to protect their employees and prevent them from contracting COVID-19. We'll see what happens. But I actually think, you know, might be issues with, you know, actually proving that's where it came from. But I certainly think that's going to be coming down in the future.
So I think that that's everything. So yeah. Thanks everybody.
Thank you.
Yeah.
You.